So the Third Circuit En Banc panel just held oral arguments on an important Second Amendment case which involves the possession of firearms by non-violent prohibited people. So let's talk about this. As I mentioned in the intro, in this video, we will be discussing an important Second Amendment challenge which just had oral arguments held before the Third Circuit En Banc panel. The case we will be discussing in this video is called Range v. Garland, and it involves a challenge to federal laws which prohibit someone with a nonviolent felony or a nonviolent misdemeanor equivalent from being able to possess, own, or to purchase firearms. Now, the facts surrounding this case are as follows. 26 years ago, Brian Range was convicted of concealing some of his income so that he could obtain additional food stamps for his family. Essentially, he simply concealed some of his income, made a false statement on a form. However, because of that one nonviolent misdemeanor conviction, the government bans Mr. Range forever from being able to purchase or possess firearms. Mr. Range brought this lawsuit originally before a district court in Pennsylvania against the Attorney General and the ATF, seeking declaratory and injunctive relief. However, the district court ruled in favor of the government on a motion for summary judgment. Now, after losing at the district court level, Mr. Range then appealed up to the Third Circuit. On review, a Third Circuit three-judge panel issued an opinion upholding the lower court's decision, and essentially they did so also citing Bruin. The three-judge panel cited history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding, responsible citizens. The panel held that that category properly excludes those who have demonstrated disregard for the rule of law through the commission of a felony and felony equivalent offenses, whether or not those crimes are violent. So here the Third Circuit panel found that his misdemeanor, although nonviolent, qualified under 922G1 and therefore excluded him from the class of people afforded the right to keep and bear arms. Well, after that decision, Mr. Range appealed the decision up to the Third Circuit En Banc panel, and the Third Circuit En Banc panel recently held oral arguments in this case. I've listened to the oral arguments a few times now, and I'm just going to give you some of the important takeaways and some of the general takeaways that I got from listening to the oral arguments. I will also leave a link down below to the audio if you want to listen to it for yourself. It's about an hour and 30 minutes. Generally, the arguments can be summarized as Mr. Range's attorney advocating for a dangerousness standard, and the government, in contrast, argues for a disregard for the law standard. Throughout the oral arguments, you hear Mr. Range's attorney argue heavily that only dangerous crimes should qualify for someone to lose their right to keep and bear arms forever. First, Mr. Range's attorney argued there are two types of dangerousness or dangers that the court could take into account. There are dangers to the public, which is the type of dangers the founders and their laws specifically targeted. The founders had laws that were concerned about treason to the nation, and therefore those people who pose that type of danger to the public at large, could lose their right to keep and bear arms. There is also the historical caveat with that, though, that those people could swear an oath to the nation and then get their rights back or prevent themselves from being stripped of the right to keep and bear arms. In fact, there is no historical support showing a lifetime restriction on the right to keep and bear arms, which the government's attorney actually conceded at the oral arguments. There is also a different type of danger, which is private danger. It's more of a danger to individuals or to maybe like companies and businesses, things of that nature. But since at the founding time, the founders and those laws were much more considered about treason and dangers to the public at large, there's not a lot of historical support which actually points to private dangers and those types of restrictions barring someone from being able to keep and bear arms for essentially their entire life after the crime. Now, in contrast to the dangerousness test, the government wanted to frame the entire issue as a disrespect for the law standard. They argue that the legislator's category of disqualifying crimes is what should be considered, and once someone essentially violates a law, they should be disqualified forever because of their crime shows a disrespect for the law. Several of the judges actually at the oral arguments pushed the government on this very absolutist position. Multiple of the judges were concerned that first, a state legislator could create a law making essentially something like jaywalking, a very minor crime, a crime punishable by more than 1 year, and therefore a person would lose their right to keep and bear arms. The government's only retort to that type of hypothetical is that the legislator wouldn't do that. Of course, the government would never do something like that. They would never target individuals. They would never go after a class of people or create crimes that would strip you of your rights. That was their only retort to that type of hypothetical. I would say that my impressions from the judges was that they did not like this type of absolutist position. They pushed back on the government's attorney quite a bit with hypotheticals and showed kind of a lack of interest in that type of position, and was asking them, do they have any other plans outside of their plan A? Is there any type of middle ground? In which ultimately the government's attorney said, no, it's kind of this absolutist position. If you violate a crime, if you violate the legislative crime or penal code or whatever, then you could lose your right forever, and there's really nothing you could do. There were also concerns by some of the judges about what dangerousness means or what dangers qualify in the context of determining who could lose their rights and who doesn't. Multiple times the judges asked about hypothetical crimes like arson, fraud, embezzlement, and others. Mr. Range's attorney took the position that there could be a category of legislative crimes that could determine you to be a danger to the public or private, but also there may need to be a case-by-case evaluation. Many of the judges appeared to be concerned about the logistics of issuing a decision in favor of Mr. Range. They worried about all of these people now who maybe were prohibited prior, having now to go to a court, petition a court to get their rights reinstated. Now, in response to this, because this is much more of a real-world logistical concern of the court, Mr. Range's attorney argued that the courts make these types of dangerousness decisions all the time. They do this quite often. They do it with sentencing. They also do it with bond hearings. So that really shouldn't be a concern. But also the fact is that it might be hard for the courts. They may have to kind of deal with the logistics of this, but that doesn't override the fundamental right to keep and bear arms. Just because maybe it's going to be hard on the courts, they have to make a case-by-case decision, doesn't mean that then we just say, well, you don't get your right to keep and bear arms because it's going to be hard on the courts. There was also a debate about who the people are, as described in the text of the Second Amendment. Mr. Range's attorney argued that the people refers to all people, not just a narrow subset of individuals like the government believes. The government argued that the people does not include individuals like Mr. Range who have nonviolent criminal convictions. The argument by the government is that those type of individuals fall outside of the political class of people considered in the text of the Second Amendment, and instead they argue that the people, as mentioned in the text of the Second Amendment, and also decisions by the Supreme Court in Heller, Bruin, McDonald, etc., only means law-abiding individuals. And since Mr. Range is not law-abiding in their eyes, he does not have a right to keep and bear arms under the text of the Second Amendment. In fact, during the arguments, a couple times there were judges that tried to get the government to ultimately concede that Mr. Range was law-abiding, that he was a law-abiding individual. However, the government would simply not admit that. Instead, the government argued that he is not law-abiding because of his prior conviction. Their position is that he can never really get rid of that status, and that he still poses a risk because Congress said he is disqualified because he has a disrespect for the law, because he violated one law. So my general takeaway from the oral arguments was that I think there was a strong base of judges that agreed that Mr. Range is nonviolent and that his life prohibition is in fact unconstitutional. However, many of them were concerned about what that means for other people and maybe how the courts will have to deal with this dangerousness evaluation going forward. Mr. Range's attorney did an amazing job, in my opinion, in answering a lot of the judges' questions and a lot of those hypotheticals. In contrast, in my opinion, the government's attorney really struggled with a lot of the questions, really struggled when he was pushed by some of the judges, and multiple times actually tried to avoid the hypotheticals, tried to fight the hypotheticals, and actually made quite a few of the judges angry on the panel. In fact, they kind of called him out with trying to skirt the hypotheticals. But that's my general takeaway from the oral arguments. If you have any questions, go ahead and comment down below and I will try to answer the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.